Next matter to come before the court this morning is Miller Lakes Community Services Association Incorporated versus Wolfgang Schmitt et al. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal if you're the appellant. You wish to reserve any time for rebuttal. I'm keeping the clock this morning. If you let me know, I can let you know what time you have left for that rebuttal. I know that we do have several employees in this matter, so that if they wish to divide their 15 minutes of time, it's helpful for the court to let us know when you stand up and divide when your time comes, so that also I can try to assist in the passage of time and let you know if getting into somebody else's agreed time. We have read briefs and we are ready to take the away.
Good morning, Your Honors, Counsel. My name is James Richard. I represent the appellant, Miller Lakes Community Services Association. As Your Honors are aware, we've been here before, and we're here today to address the argument based upon the appellant's assignments there. I want to first begin, by the way, I'd like to reserve 5 minutes. I would like to first begin by readdressing some of the facts in spite of this long history. The memorandums of the parties have different recitals of the facts, so I want to initially refer to what I believe are the facts. My client, Miller Lakes, in its present form, acquired title to this property, being the common area, Middle Lake Road, the lakes, and other areas, in June of 1999. However, prior to that time, and after that deed, Arthur Miller Park Corporation operated all of those common areas, including the road. And Arthur Miller Park Corporation was the only party of interest insofar as the declarant is concerned, and Arthur Miller Park owned all of the property and other property that was subsequently transferred to the Schmitts. And so I believe those statements are undisputed, and the various declarations and covenants and ownership issues are set forth in this record, and they are set forth in part as Exhibit R to the, which was admitted to evidence at the hearing on the summary judgment. There's also a color-coded map. That color-coded map was admitted as Exhibit A to that same summary judgment hearing, and is actually an appendix to the appellant's brief. Now that map shows ownership in 1990, prior thereto, and the present time. And the authenticity of that map was never challenged. It discloses all of these owners and when they existed and when they acquired title. Clearly, the ownership of Miller Lakes at the time of the Applebee's deeds, the Schmitts under the integrated agreement, was not for owners. I don't know where that argument surfaced and when. I can tell you where it exists. It exists in the affidavit of Tony Schmitt that was attached to her cross motion for summary judgment. But that affidavit is dated, I believe, July 10th, 2009, and it recanted her similar sworn statements 2 days earlier in another sworn document, an affidavit. But the bottom line is, for purposes of summary judgment, the facts as evidencing owners and when the owners took title, how many owners existed, are clearly established in this record, and there were 18 owners, not 4. And again, the only evidence you will find anywhere in this long record is this affidavit of Tony Schmitt, where she somehow came up with this argument. Now, with regard to the assignment of heir and the number of owners, we only get into how many owners in the course of the conduct there are, and the course of conduct since the deeds were recorded, if these issues are not removed as a question of law. Now, when a deed or easement is executed, it's presumed to be valid, and it cannot be extinguished, set aside, or modified absent the showing of clear and convincing evidence. This issue has been addressed at the trial court, but the trial court has ignored this. The trial court jumps to, I'm not going to answer that question. I'm not going to look at the intent of the parties at the time that the easement was created. And I'm talking about all three easements. I'm going to look forward to what happened after it was created. I submit that is an error in and of itself. But these easements on their face are clear and unambiguous. And they cannot be changed or modified without a showing of the burden of proof of clear and convincing evidence. After all the remands from this court, on each occasion, I raised these issues with the trial court. I addressed the burden of proof. I addressed at the trial court examine the questions of fact, but also look at the burden of proof of clear and convincing evidence. There is no addressing in any of the decisions of the trial court of these substantive issues. Again, the trial court just jumps forward to other issues. And there also is the burden of proof by clear and convincing evidence addressing the finality of real estate transactions. You simply, and also the doctrine of merger by deed, absent a showing this type of situation in clear and convincing evidence, the deed or the easement cannot be changed. I noted from listening briefly to the prior argument, there was reference to a railroad right-of-way. We're not here talking about a long period of time, and there was also reference to oil and gas. This court has cases before it now dealing with perpetual leases and the questions of perpetual leases. But what has the court examined in all those cases? They look at the intent of the parties 30 years ago, not 15 years ago, or 50 years ago, and say, what did the parties intend there, and did they intend to create something perpetual or permanent? Now here, again, the trial court jumped forward to something that allegedly happened after these documents were created. Now, for summary judgment purposes, we're looking at a de novo review, and we submit that the credible evidence in this record is as set forth by the appellant. Now, let's look for a moment at the easement language. The court and the questions of hearsay, parole evidence, and extrinsic evidence. What the trial court did in fashioning this mutual interpretation or mutual understanding was seize on certain evidence that was submitted only in affidavit form by the appellees, claiming certain conversations with third parties, people who are dead now, that they were told before they signed their contracts and purchased property. The court again looked at those conversations before the contract and ignored the legal documents that apply, such as merger by deed. And then they look at what allegedly occurred after that time and claimed that Middle Lakes apparently waived or is a stop from enforcing this. Well, number one, as mentioned, Middle Lakes did not become in control of the property until 2002, and it sent invoices out in 2006. Prior to that time, we have the Hall affidavit where the Coopers, the appellees, are addressed, and there's no challenge to the fact that they made payments, but they claimed the payments were gratuitous. But the bottom line is, and we have the payments by Tony Schmitt, which exist in this record, which the court simply ignored. But the bottom line is, even if we look at that course of conduct after the deeds were recorded, that course of conduct does not support the arguments of the appellees. We have clear, unambiguous declaration of restrictions, and we have the doctrines of constructive notice. We are dealing with sophisticated appellees. They know what constructive notice means. The declaration of restrictions specifically describe the Schmitt property that was sold. They specifically describe the Cooper property, and they specifically describe the Jacobs property. So all those properties are described. And it isn't a question of what they paid to the association or Middle Lakes now. When Jacobs owned the property, Wiggum's predecessor, there would be no reason for him to pay Middle Lakes because Middle Lakes didn't exist. Arthur Miller Park was who he paid. So we have these quotes attempted quotes from Jacobs and unsigned affidavits from Jacobs that are adopted as fact by the trial court, going to, oh, Jacobs didn't pay Miller Lakes. Well, Miller Lakes only existed in 2002. Arthur Miller Park Corporation existed since 1988 and is a declarant and created all this, and the deeds were all subject to those restrictions. And they specifically also indicate that waiver, estoppel, does not apply even if we fail to make assessments. Again, it's not a question of did Miller Lakes force them to join an association. The answer is no, but they took title with constructive notice of the fact that they were required to pay, and even if Miller Lakes or its predecessor didn't ask them to pay, they were not subject to waiver, estoppel, or laches. Now, the concept of estoppel and promissory estoppel adopted by the trial court is also flawed. As this court is well aware, that requires not only detrimental reliance, but fraud and concealment or false representations. There is nothing in the decision of the trial court that finds any false representations, finds any concealment, finds anything suggesting detrimental reliance. It just goes to this mutual understanding that it found to be supported by hearsay statements or parole evidence by third parties not involved with this litigation.
And counsel, you just now reached that 5 minutes.
Okay, well, thank you.
Good morning, Your Honors. May it please the court, counsel, I'm Robert Kehoe, and it's my privilege to appear before you this morning on behalf of Wolfgang and Tony Schmitt. We'll divide our time on App.No's side about 5 minutes each. And so let me attack the first issue about a final appealable order. I submit to the court that the trial court has addressed all of the issues raised by this court in that its most recent decision resolves all of the claims and counterclaims of the parties and declares the rights and obligations and the benefits and the burdens of the easement that is the subject of this lawsuit. If the court does not have any questions about the finality of the trial court's order, let me proceed to the merits of the underlying summary judgment. For the first time on appeal, the appellant raises an issue of language in the declaration. This argument was never made in the trial court, it was never made in any prior arguments before this court, and there's really a pretty good reason for that. The declaration does not appear in any of the deeds at issue. One of my colleagues will address this issue in detail, but simply stated that is not a genuine issue of material fact on summary judgment because the declaration language does not appear in the deed. It's that simple. You don't imply any rights or obligations because they don't exist. If it appears in the deed, it's a covenant that runs with the land and it's enforceable. If it doesn't, it's not an issue of fact that we need to talk about. What is clear and undisputed is that none of the deeds at issue here have any easement language, with the exception of one. The Coopers and the Wiggums do not have any easement language about paying for road maintenance at all. There are 6 deeds at issue with the Schmitts, not one. One of 6 has language concerning road maintenance, but the other 5 do not. The trial court properly found that there's no issue of fact that the deeds at issue do not have language concerning maintenance and costs to maintain the roadway, with the exception of the one Schmitt deed. So the trial court properly looked at the conduct of the parties. Under the Burgess and Neipel case, the trial court interpreted the intent of the parties by their behavior over 17 years of performance. Over 17 years, there was a very agreeable and cooperative arrangement where Miller Lakes, which admittedly had the obligation to maintain the roadway, did so at its cost and did not bill Schmitts, Coopers, or the Wiggums. As a quid pro quo, the Schmitts maintained the trees and a drain and the north side of the property, landscaping, leaf removal, plantings, and so forth. And the Wiggums and the Coopers maintained the south side of Miller Lake Road. So the trial court determined that for 17 years, this arrangement was agreeable to the parties, and in declaring the rights and obligations of the parties, set forth a very specific obligation on the part of Miller Lake Association to maintain the roadway, giving the right of ingress and egress to the Coopers, Wiggums, and the Schmitts, and holding them accountable to maintain their part of the surrounding area on either side of the roadway. So the questions that this court raised about declaration of rights and obligations is clearly answered by the trial court in declaring specifically that the shared benefits, which are the snow removal, surface maintenance, utilities, underground subsurface maintenance, are all on the account of Miller Lakes Association. And in consideration of that, the Schmitts, the Wiggums, and the Coopers will maintain the surrounding area. So the rights and obligations of the parties have been specifically declared. There's no misunderstanding as to what the rights are going forward for future use and future buyers. As a result, there's nothing for a court to try. Summary judgment was appropriate, and the trial court's decision should be affirmed. If there are no questions from the panel, I will yield the balance of my time to my colleagues. Thank you.
May it please the court, Mr. Richard. My name is Bob Reynolds. I'm here on behalf of the Coopers. Mr. Richard indicated that as opposed to the railroad situation, this was a relatively recent development. I beg to differ. My clients have owned their property for almost 40 years now. And as Mr. Kehoe indicated, there's no reference in their deed to this declaration or amended declaration that's referenced by Mr. Richard. And there's a very good reason. By the time this was signed in 1989, they'd already owned their property for 12 years. Their ownership of their property predates this declaration by 12 years. It's important to note that this declaration, I would encourage the court to review that because it is signed solely by Arthur Miller Park Corporation, the predecessor in interest to Miller Lakes Association. There are consents by other parties, but it's a unilateral declaration. And it clearly divides the property that's referenced in it into two categories. Property that's part of the development and property that is not, but could potentially be added in the future. And the property owned by the Coopers is clearly designated as such. I believe it's described as parcel 12 on the list of properties that can be added. The property currently owned by the Wiggums is referenced as property that could be added. It's identified as parcel number 9. I believe the property owned by the Schmitts is also referenced, although at that time it was owned by Arthur Miller Park Corporation, it's parcel number 1. These are properties that are described as being capable of being added to the development. But the declaration is crystal clear that that addition can only be made with the consent of the owner of that property. So basically, similar to a condominium declaration, it provides a means to expand the condominium, saying, okay, here's what we're starting with. We foresee the possibility of expanding the condominium at a later date. Same with this development. There were adjoining properties, had a similar background, said if these owners consent, and provided there's sufficient vote among the owners in the development, we could expand this to include those properties. If the owners of those particular properties agree to come in, and obviously if you would agree to come in, you'd submit to all the rules and regulations in the development. That is not the case here. Neither the Wiggums, the Coopers, or the Schmitts have indicated whatsoever that they want to be a part of this. In fact, their ownership was separate and apart. They've made that clear from the outset. It's interesting to note in 1989, again, that's 26 years ago, when this declaration was entered into, you would have thought that if Arthur Miller Park Corporation believed that they had the right to claim assessments against any of the parties that were outside of the development, they would have enunciated those claims. Nothing in the declaration gives any indication of the sort. And there's a reason for that. What would have given them the belief at the time that they could unilaterally announce to adjoining owners that they had a right to assess their properties? 26 years later, Mineral Lake Community Service Association doesn't see a problem in doing so, and that's why we're here today in court. If anyone has questions about the declaration, again, I would encourage you to review the declaration, note the distinction between the two classes of property, property that is in it and property that can later be included in it. The inclusion is available only if the owners of the property in question voluntarily agree to become a part of it. There's no ability to annex the property against the wishes of the owner. And in some ways, that's exactly what the appellant is seeking to do here today. Thank
you. May it please the court, my name is Luke Palmer. I'm here on behalf of David and Becky Wiggum. I want to address two issues quickly here raised by the appellant. The first is that the appellant is now saying, I think for the first time, that we should look back at what happened when the easement was entered into, when the easement was actually set up. But if you look at the appellant's brief, the two cases the appellant cites, both of those cases where there was an easement that was silent as to maintenance and cost, the court looked at conduct that occurred after the fact and looked at how did the parties interpret this agreement by their conduct. And so even the appellant has agreed that that is what you need to do, is to look at forward conduct, what happened, how did these parties treat the easement. If you look at that, there's no dispute about that here. There's no dispute as to what the parties did to maintain, and I think my colleague, Mr. Keogh, set that out at the beginning, what the Schmitts did, what the Wiggums did, what the Coopers did, and what the association did as well. But the other issue I want to address is the hearsay statements. This is an issue that was not raised at the trial court level. There was an affidavit submitted saying that there were conversations, there were statements made to the Wiggums at the time they purchased the property that they would not have to pay association dues, they were not going to be in the association, they would not have to pay to maintain the road or anything else. If the appellant wanted to object to that as hearsay, the appellant had to do that at the trial court level. Now, they said we did object, but if you go back and read the actual memorandum in opposition, all they say is that that wasn't sufficient evidence to reform the deed or to set aside the deed. They didn't actually expressly say, well, these are hearsay statements in trial court, you should not even consider these statements. But even if those were hearsay statements and those were excluded, there was still deposition testimony from Mr. Jacobs, the Wiggums' predecessor in interest, where he said, he was asked, did you ever pay maintenance fees for the road, for Miller Lake Road? His response, no. The second question was, were you ever asked to pay maintenance fees for the Miller Lake Road? I don't recall that I was. So there again, you have an indication. Did Mr. Jacobs sign an affidavit? No. But he testified under oath. I never paid fees, and I don't recall ever being asked. And finally, on this issue of payments with respect to the parties, if there were actually payments made by any of the parties, I would think that the association would be able to come forward with some evidence showing that payments were actually made, and they don't have it. With that, I'd ask that the appellate court affirm the trial court's decision unless there are any questions. Thank you.
Thank you. As I mentioned during my initial argument, there are obviously differing opinions and disputes of fact here, but the appellant is confident that the court will look through this record again and will agree with the appellant's arguments. I want to address one thing that all three appellees addressed that simply isn't the case. We are not raising any arguments new in this appellate brief that we filed. The declarations, as I mentioned, are voluminous, and there are 5 amendments to them recorded, and they were introduced into evidence at the summary judgment hearing. And they are, I quote Exhibit R, on numerous occasions in all of my memorandums, going back to the first appeal. The only thing that is new, if you will, on this memorandum that I filed is I actually, instead of referring to the declaration said this, I quoted the provisions. But there is nothing being raised on appeal that wasn't raised at the trial court level during the summary judgment proceedings. It's simply an argument, I believe, to attempt to divert this court's attention, saying we're trying to raise something new. And with regard to not objecting to the hearsay, I'm confident the court will look at this record and see all of my objections in the memorandums. We did not raise hearsay objections for the first time on appeal. That simply isn't the case. But I also want to, with this rebuttal time, address what counsel for Schmitt's indicated about the final non-appealable order. The appellants are not requesting another remand due to a final non-appealable order. We are simply pointing out that it is obvious after 3 prior remands and repeated requests by this court and the appellants to address certain issues that the trial court is not going to. And we've been here 3 times with oral argument and 3 times memorandums, and it's our position that this decision should be addressed and the errors in this decision should result in a reversal. And if I may, the transcript to remove any disputes on that subject from the summary judgment hearing of the court itself reads as follows. With regard to the Exhibit R, these declarations that are voluminous, that everybody's referring to, His Honor says, with regard to the facts, the court is going to consider all of this. In the decision, it will specifically refer by exhibit letter, this is A through OO, that we introduced into evidence, to the exhibits that the court deems relevant. So for purposes of any appeal, it will be clear, you know, what the court considered as fact and as not disputed fact. I'm going to consider it all. There is no reference in any of these 4 decisions to the trial court doing that. Not one. The proposition of law I previously addressed, and it is clear that proposition of law merely indicates, as it applies to Cooper and Wiggums, that is it when one party confers a benefit with another without receiving just compensation for the reasonable value of that service or benefit, does the law create a claim against the other party for the reasonable value of the services provided by that party. That is in the assignments of error, that is in the memorandums, and there's not one mention of that proposition of law. That proposition of law was answered in the affirmative, saying, and it touches on unjust enrichment and quantum merit in the case of Colas versus Wonder and the Somerville case. Those courts and those appellate decisions said that was a reasonable proposition of law, and when the deed is silent, it should be implied and found to be the case that it's only reasonable for everybody to share their pro rata cost. And I submit there's a reason today in argument you don't hear any reference from the appellees to those cases, because we do have a precedent here. I submit, however, and with regard to what the
Counsel, thank you for informing that I've utilized the remainder
Okay.
of the time. Thank you
Well,
for
thank
your
you.
presentation this morning.
Yeah.
Thank you all for your presentations. The court will take